Hello, everyone. It's Nicole Gaither, owner and managing attorney of Creativa IP Law. And today is Tuesday, so I'm coming to you with your Tipsy Tuesday tip. So I was in the process the other day of doing a comprehensive clearance search for a client. And she has a service-based business. She's a podcaster, but she wanted to also file a trademark related to a phrase that she wants to use in conjunction with a podcast. And so she, of course, wanted to put it on a t-shirt. So we had to talk about the proper way of filing a trademark for a phrase, and especially if you wanted to use it on apparel. So during her search, I also noticed a couple of applications that had been filed and either were declared dead by the trademark office, which means that either the person decided they didn't want to go forward with the application, or they didn't respond in time to something. Generally, it's usually an office action, or and it's usually an office action that's for something as complicated as someone else already has a application, a registration that's already very similar to what you're filing for, or there's something pending that's similar to what you're filing for, or it's as easy as if you have, you're filing for something, an apparel, usually it's a t-shirt, and it's always something that, people want to have like on the front of the t-shirt that they want to trademark and register. Then they submit what's called a specimen, which is the evidence of the mark in use. They submit it's early, y'all. They submit a specimen, and it's not exactly in line with what the trademark office is looking for. So they get a refusal from the trademark office, and it's usually an initial refusal. So that means that, all is not lost, but they get a refusal saying from the trademark office that this, the specimen you submitted doesn't show us how you plan on using this as a brand. All you submitted is something like a design, and it's considered ornamental. So it's an ornamental refusal. So I kind of wanted to show an example. It looks like someone has already filed and registered a trademark for Girl Dad. And I know that became very popular after Kobe Bryant passed away, thanks to his wife recognizing his strong ties to his daughters. She had the hashtag Girl Dad that ended up going trending, or I think it was. Correct me if I'm wrong, because news stories come out and certain things are said. But apparently someone else had already registered Girl Dad back in 2016 because of her husband's ties to her daughters. So she registered Girl Dad in connection to apparel. And it's not really funny, but the amazing thing is this is a great example of what I'm talking about when I mentioned that if you're going to file something related to apparel and you want to protect a phrase that, is trending, popular, which again, I have something on this already, we can't all go file a trending phrase because it's popular. And there's already, like I said, a registered trademark in the apparel line for Girl Dad. Two other people went and tried to, file applications for it, like right after Kobe passed away. And I guess when this hashtag became a trending hashtag. So you already have two people who are not even related who have filed for hashtag Girl Dad for apparel. And then now there are two other Girl Dad applications that are out there, but they're not for apparel. They're actually for entertainment services. And I guess like maybe a podcast related to father-daughter relationships. So that should be interesting. They might be able to move forward with theirs because it's not really related to the apparel ones. And if they just show, the proper usage and evidence of it. So we will be monitoring those situations. But I wanted to show you an example of what I mean when I'm talking about a specimen that has been submitted to the trademark office. And generally, this is the most popular refusal I see. And this is the reason why most people abandon their applications. And it's such an easy fix if you had either talked to an attorney about this and had an attorney help you file the application, or when you got the refusal, that you went to an attorney and asked them to help you file what is necessary so that you can keep your trademark application alive and to move forward with it. Because you've spent money, why not just spend on something a little extra to get an attorney to help you file it to get it all the way to the end? I mean, do you not want it? This kind of perplexes me when I see applications that are dead that someone has spent money to file, but then go forward with it. Like you did a mock-up or you even got shirts made. Are you not selling them anymore? I don't know. But let me see if I can do a screen share and I will show you all what I'm talking about with that. Let's see, because I'm technologically just not advanced sometimes. Okay, so let's see. All right. So like I said, if you all can see my screen, there are five, just for me doing a search for girl dad, there are five, there's one out in registration, one thing has been registered, and then there are two hashtags, and then these two here. So literally there are five related girl dad kinds of things. Three of them are all in the same class. These top two here are for the entertainment related services. So going to, so this girl dad is the one that was registered, and it was registered back in 2016. So it was filed in 2016, sorry, it was registered in 2017 by Hillary Wharton. And she filed it and got it registered under baseball caps and hats, shirts, socks, sweatshirts, t-shirts, camouflage shirts, polo shirts, and rugby shirts. And she has her date of first use as April 30th, 2016. And she first started using the mark in commerce, which means that she started selling it in a state outside of hers, according to what she's saying. And she has declared that she started selling this on May 28th, 2016. So just kind of want to show you all, as you can see here, this is the path that her application took through the trademark office. And some of these things are just like internal notes that the trademark office uses, like they make notes to the file, they do a search. Here's her application. Here was probably the drawing of the application, the actual like mark, as she put it, girl dad. Then she submitted a statement of use to say that she started using it and gave them a date, probably which was that May 28th date. And then she submitted a specimen. However, if you see, and if I can get to it, if my screen would let me, because this is blocking it. This is the specimen she submitted, the t-shirt with girl dad on it. That's where a lot of people go wrong. And then also, this is where she kind of also went wrong. She already has the circle R on it. Like, you don't have a registration. You cannot use the circle R until you have a registration from the USPTO. Until you have a certificate and a notice that says that your trademark has been registered, you cannot use the circle R. So don't do this. Do not submit specimens that have circle R and you don't have a registration. Okay? So she got an office action for this specimen. This is the evidence she submitted that shows girl dad, which she can use this on a shirt, but this is not showing evidence that this mark is being used as a brand. So then she received an office action based on that, and she responded to the office action, and she hopefully got an attorney. So this is what she submitted in response to the office action. She has now the tag attached to the shirt, which generally a tag, like a hang tag, or I'm going to show you all in a second, but generally a hang tag with the brand name will suffice as showing the mark as in use for what you're trying to register it for. Again, I don't know how she got by with this circle R that I'm sure is right there, but she did get this as it was accepted as evidence for her mark in use. So I'm going to stop the screen share so I can show you all something else. All right. So like I said, and I only had one shirt that had a tag on it. Amazing. Probably because I meant to return this shirt, but I forgot. So if you can see, this is a hang tag. Yes, it's a large. I was going to return the shirt, like I said. But you can also see it says INC. And so this is the brand of the shirt. And I'm going to show you all. This is what I also mean when I'm talking about like the label inside of a shirt. So like this was made by INC. So you have the hang tag, which shows the brand, and then the tag inside the shirt. And then also because, as I said, apparel and t-shirts seem to be the popular thing that people file to try to get, protection for a phrase. So I don't have a phrase, unfortunately. This was the only t-shirt that I could find. But as you can see, this is, it's a Izzy and Liv shirt, and it's got a design on it. They're not trying to protect this design, even though it's a graphic. They probably could protect it via copyright law. If they want to protect it via trademark law, they literally have to use this logo as their brand. So, sorry, don't worry about me. So they have to use this logo would have to be actually on one of those hang tags or inside the shirt. So as you can see, the brand of the shirt is Izzy and Liv. So that's imprinted on the inside of the shirt. So if you are trying to file a trademark application related to apparel and you want to protect a phrase that you're using, like either it's a catchy phrase or something that you want to, promote related to your business, like you have a podcast or your coach or whatever, then you need to do it the right way if you want to get that proper protection. So hopefully this has been helpful. Like I said, I've seen so many office actions related to this. They're easy fixes if you do it right, if you go to the right person. And they're preventable, because if you'd done it right the first time, then you wouldn't have even gotten it. But neither here nor there. If this is something that you have gotten and you want to try to, you want to make sure that you can move forward through the process, please feel free to contact me. Schedule an appointment, send me an email, and we can talk through it. And this is something that I've helped several people do throughout the process. Email me, Nicole@creativaIPlaw.com, or hit me up in the comments or send me a direct message, and we will connect and see if we can schedule an appointment, do a consultation. We can discuss what needs to be done if you would like help with it. And it's very, like I said, all we need to do is just make sure that we submit the proper evidence, which some of it you have to do on your end, but I can at least guide you through that process. So happy trademarking. It is another Tuesday in this great week. What is it, second week of February? Yeah, January was long. So anyway, I will talk to you all soon. Bye.